Understanding your rights as a worker in the UK is crucial. It's about more than just knowing when you can take a break or how much you should be paid. It's about feeling secure, valued, and respected in your workplace. Knowing your rights empowers you to speak up if something isn't right and ensures you're treated fairly. This knowledge can make a real difference in your working life. Think of it like this. Your employment rights are your safety net. They are there to protect you from unfair treatment and ensure you're treated decently by your employer. Whether you're just starting your career or you've been working for years, understanding these rights is essential. It helps you navigate the world of work with confidence and ensures you're not taken advantage of. It's not just about avoiding negative situations. Knowing your rights can actually lead to a more positive work experience. When you feel secure and confident in your position, you're more likely to be productive, engaged, and happy at work. This benefits both you and your employer, creating a more harmonious and productive working environment. So take the time to learn about your rights as a worker in the UK. It's an investment in yourself, your career, and your future. Remember, knowledge is power, and understanding your rights gives you the power to shape your working life for the better. Before we dive into the specifics, let's clarify the different types of employment contracts in the UK. This is important because your rights can vary depending on your employment status. Generally, there are three main categories: employees, workers, and self-employed individuals. Employees have the most extensive rights. They work under a contract of employment, meaning their employer has control over their work, hours, and place of work. Employees are entitled to benefits like paid holiday, sick pay, and redundancy pay. Workers have fewer rights than employees, but are still entitled to basic protections. This category includes those working on 0-hours contracts or agency workers. Workers have the right to the national minimum wage, paid holiday, and rest breaks. Self-employed individuals are their own boss. They have more freedom and flexibility, but are responsible for their own taxes and national insurance contributions. They don't have the same employment rights as employees or workers. Understanding which category you fall under is the first step to knowing which rights apply to you. If you're unsure about your employment status, you can seek advice from ACAS, a government-funded organization offering free and impartial advice on workplace rights. Even before you start a new job, you have certain rights. One of the most important is the right to a written statement of employment particulars. This document outlines the key terms and conditions of your employment, including your job title, pay, working hours, and holiday entitlement. You're also protected from discrimination from the get-go. This means an employer cannot discriminate against you based on factors like age, gender, race, religion, or sexual orientation during the hiring process or throughout your employment. Once you start working, you're entitled to the national minimum wage, regardless of your age or job role. You also have the right to rest breaks, paid holiday entitlement, and a safe working environment. These rights are fundamental and apply to all workers, regardless of their employment status. Remember, these rights are not privileges. They are your legal entitlements. Your employer is legally obligated to uphold these rights, and you should feel empowered to raise concerns if you feel these rights are being violated. Don't hesitate to seek advice from ACAS or a trade union if you need support in understanding or asserting your rights. We all need a break, and the law recognizes that. As a worker in the UK, you have the right to paid holidays, even if you work part-time. The current statutory minimum is 5.6 weeks of paid holiday per year, which can be prorated based on the number of hours you work. But it's not just about holidays. You're also entitled to time off for other reasons, such as sickness. If you're off sick for 4 days or more, you're entitled to statutory sick pay, SSP, paid by your employer. When it comes to getting paid, your pay slip should clearly show your gross pay, any deductions like taxes and national insurance, and your net pay. You should receive your pay slip on or before your payday, either electronically or in paper form. Remember, these are just the minimum entitlements. Your contract of employment might offer more generous terms, so always check your contract carefully. If you have any questions about your holiday entitlement, sick pay, or payslip, don't hesitate to speak to your HR department or consult ACAS for free and impartial advice. Understanding the minimum wage. The national minimum wage is a legal safety net, ensuring everyone working in the UK earns a fair wage for their work. The minimum wage you're entitled to depends on your age and whether you're an apprentice. It's important to remember that the minimum wage is the absolute minimum an employer can legally pay you. Many employers choose to pay above the minimum wage, particularly for roles that require specific skills or experience. If you feel like you're being underpaid or have concerns about your wages, the first step is to talk to your employer. They might be unaware of the issue or willing to rectify it. If you're uncomfortable approaching your employer directly, you can contact ACAS for confidential advice and support. Remember, being paid a fair wage is your right, not a privilege. Understanding the national minimum wage and your rights ensures you're being paid fairly for your hard work and contributions. Don't hesitate to seek help if you believe you're being underpaid. Your rights are there to protect you. It's normal to encounter issues at work from time to time. It could be something minor, like a disagreement with a colleague, or something more serious, like concerns about discrimination or harassment. Whatever the issue, it's important to remember that you have the right to speak up and address these concerns. Most workplaces have a grievance procedure outlining the steps you can take to raise a formal complaint. This usually involves putting your complaint in writing and addressing it to your manager or HR department. Your employer has a legal obligation to take your grievance seriously and investigate it fairly. If your employer doesn't have a formal grievance procedure or you're uncomfortable using it, you can still raise your concerns informally. This might involve speaking to your manager, a trusted colleague, or a trade union representative. Remember, addressing workplace concerns can be daunting, but it's important to remember that you have the right to work in a safe and respectful environment. Speaking up not only benefits you, but also contributes to a healthier and more productive workplace for everyone. Sometimes, despite our best efforts, workplace disputes can escalate and become more serious. If you've tried to resolve an issue through informal means or your employer's grievance procedure, and you're still not satisfied, you might need to consider other options, such as mediation or employment tribunals. Mediation involves a neutral third party who helps facilitate a conversation between you and your employer to try and reach a mutually agreeable solution. It can be a more informal and less adversarial way to resolve disputes than going to court. An employment tribunal is a formal legal process where you can present your case against your employer. This option should be considered as a last resort, as it can be a lengthy and stressful process. It's crucial to seek legal advice from a qualified solicitor before considering this route. Remember, dealing with workplace disputes can be challenging, but it's important to remember your rights and seek appropriate support. Whether through mediation, ACAS conciliation, or legal advice, there are resources available to help you navigate these situations and reach a fair resolution. Redundancy is a situation where your employer no longer needs someone to do your job. It can be a worrying time, but it's important to understand your rights and the support available to you. If you're being made redundant, your employer must follow a fair and legal process. This includes consulting with you, providing you with adequate notice, and potentially offering you alternative employment within the company. You might also be entitled to redundancy pay, calculated based on your age, length of service, and salary. Your employer should provide you with a written statement outlining your redundancy pay entitlement. Remember, redundancy can be a difficult experience, but it's not your fault. Understanding your rights, seeking support from ACAS or a trade union, and exploring your options can help you navigate this challenging time and plan for your future.